Your Excellencies, honorable judges, distinguished guests, ladies and gentlemen, good morning. I'm honored to welcome you all to the second Judicial Colloquium on the new face of atrocity, crime proceedings, internalization of standards, regional dialogues on procedural and cooperation matters, and use of new technologies. My name's Saida Joy Kessie from the External Relations of the Mechanism Office. I'm pleased to serve as your moderator for this important event. I now welcome you to the formal opening, and we shall have remarks from the Honorable Ambassador, Dr. Pindi Hazara Chana. Karibu.
Good morning to you all and welcome to Tanzania, welcome to Arusha. I believe we have Tanzanians here, so let me greet you all by saying our great greeting. Na wasalimu kwa jina la Jamhuri ya Muungano wa Tanzania. Mnaniangusha jamani. Na wasalimu kwa jina la Jamhuri ya Muungano wa Tanzania. Asante sana, asante sana. Honorable Judge Graciela Gatti Santana, President of the International Residual Mechanism for Criminal Tribunals. Honorable Lady Justice Iman Daud Aboudi, President of the African Court on Human and People's Rights. Thank you very much for being together with us this morning. Honorable Justice Nestor Kayobera, President of the East Africa Court of Justice. Allow me also to keep on recognizing Madam Alice Wairimu Nderitu, United Nations Under Secretary General and the Special Advisor on the Prevention of Genocide. Honorable judges present here today. Professor Kennedy Gaston, Deputy Attorney General of the United Republic of Tanzania. My fellow legal practitioners, representatives from the academia, ladies and gentlemen, invited guests, once again, good morning to you all. I feel very privileged to have been given the honor of opening this second Judicial Colloquium organized by the United Nations Residual Mechanism for Criminal Tribunals. My sincere appreciation for the invitation and congratulations for organizing this important event this morning here in Arusha. I am aware that many of the honorable judges and invited guests have traveled from outside the country to United Republic of Tanzania. We say welcome, we say karibu sana in Tanzania, karibu sana Arusha. Therefore, I take this opportunity to warmly welcome you all to the United Republic of Tanzania and a special welcome to the city of Arusha. Karibu sana. I would also like to extend to you greetings from our President, Her Excellency, Dr. Samia Suluhu Hassan, President of United Republic of Tanzania, who understands that this morning we are here in Arusha, and who is a strong proponent, a strong advocate and supporter of international justice in consideration of human rights principles of equality before the law and equal protection by the law. She takes great notice of the significance of this meeting and wishes all a successful session. We in Tanzania, we say under Dr. Samia Suluhu Hassan, our president, we are safe. We observe the rule of law in the country, and these have been the directives of Her Excellency Dr. Samia Suluhu Hassan. Very recently, Her Excellency formed a special committee for issues of legal justice. And this very committee has given us a lot of recommendations. And now we are performing the so-called 4 Rs: reforms, reconciliation, rebuilding. So we have 4 Rs. These are all directives by Her Excellency Dr. Samia Suluhu Hassan. And that's why we say Her Excellency is a strong advocate and supporter of issues of international law, issues of human rights, and the rule of law. So, honorable judges and distinguished guests, it is very appropriate for this session to be held in Arusha, which is progressively transforming into a peace and justice city. I say this because many organizations on human rights, many institutions are situated in Arusha, such as the United Nations International Residual Mechanism for Criminal Tribunals, the African Court on Human and People's Rights, the East Africa Court of Justice, and the African Union Advisory Board Against Corruption are located in Arusha. And as many of you are aware, the United Nations International Criminal Tribunal for Rwanda was located in Arusha too. It is a special occasion to be able to meet with so many eminent jurists and legal practitioners from different jurisdictions, all working towards the common objective of an international criminal justice system that ensures, therefore, they ensure that there is no impunity for some of the most evil crimes committed by men. Therefore, it is prudent to have an international criminal system that is responsive to the commission of brutal crimes. Not only brutal crimes, but I can say atrocious crimes. So, honorable judges and distinguished guests, during the 2005 United Nations World Summit, heads of states and government reiterated the responsibility of every state to protect its population from 4 crimes. These crimes are genocide, war crimes, crime against humanity, and ethnic cleansing. Some states have anti-atrocity legislations in place, and others have early warning mechanism based on the state's obligation to protect human rights, while others are still trying to understand these crimes based on their own context. International and regional courts have indeed played a pivotal role in developing the definition of atrocity crimes. In this regard, I commend you for this noble work and encourage you all, as it can be painstaking, difficult, and at times even dangerous. You have indeed committed yourself to a life of servitude for justice, and be assured that you are playing a definitive role in making the world a better place. The institutions you represent or have worked in have made groundbreaking decisions and set precedents in international criminal law. For example, the famous Akayesu case at the ICTR, where the court held that issues of rape is an act of genocide, and cases at the ICTY, including the Milord Nojelak case, where it determined that enslavement and persecution could be considered as crimes. Therefore, the concept, ingredients, and ramification of atrocious crimes continues to develop. Honorable judges and distinguished guests, the various panel discussions that you shall deliberate on have touched on the entire administration of justice chain to ensure that the right to a fair trial is being upheld and accused persons, victims, and witnesses. The topics range from safeguarding human rights in criminal proceedings, including the right of the accused and the right of the victim, the accused's fitness to stand trial, and the accused person's representation, access to justice for persons with disability, the fundamental aspect of cooperation between states in order to arrest perpetrators or secure victims and witness, and of course, as we are in the digital era, the highly topical issue of the use of technology nowadays to expedite justice. Therefore, it can be seen how important forums such as this one, where eminent jurists, seasoned practitioners, and experts come together, converge, share experience, and exchange ideas with the common objective of ensuring there is no impunity for the perpetrators of atrocious crimes. Recommendations made here can also be tabled before international law systems and contribute towards international criminal justice, so that the intention behind the words "never again" are a reality. We always say never again. So we need this intention of saying never again becomes reality. Honorable judges, distinguished guests, I wish to conclude by underscoring the importance of the work you do and wish you all a successful session today. I now declare that the second Judicial Colloquium is officially open. Thank you very much for listening, and thank you very much for your attention. I say asante sana.
Asante sana. I'll now welcome and introduce the panelists. Judge Graciela Gatti Santana, President, International Residual Mechanism for the Criminal Tribunals. Honorable Lady Justice Imani Daud Aboud, President, African Court on Human and People's Rights. Honorable Justice Nestor Kayobera, President, East African Court of Justice. Welcome.
Excellencies, ladies and gentlemen, dear friends and colleagues, I extend a heartfelt welcome to all of you on this wonderful occasion here at the Mount Meru Hotel. As many of you may not know, parts of the Arusha Accords were negotiated here in 1982, when this was still the Novotel and one of the first hotels in Arusha. So this place has a special significance for us. Let me start by thanking Her Excellency Ambassador Dr. Pindi Chana, Minister of Constitutional and Legal Affairs, for her inspirational opening remarks. Your Excellency, we are truly honored by your presence here today and for your words. These words have set the tone for what I expect to become a most interesting and truthful conference. I am Judge Graciela Gatti Santana, the President of the International Residual Mechanism for Criminal Tribunals, which, as you certainly know, is mandated to continue the remaining functions of the International Criminal Tribunal for Rwanda and the International Criminal Tribunal for the former Yugoslavia. It is my distinct privilege to host this second judicial colloquium for the mechanism, made possible through a generous donation by the late Benjamin Ferencz, former prosecutor at the Nuremberg military tribunals, and his son, Professor Donald Ferencz. As Benjamin Ferencz once asserted, there can be no peace without justice, no justice without law, and no meaningful law without a court to decide what is just and lawful under any given circumstance. On this note, I am particularly honored to open the colloquium together with two esteemed colleagues, the President of the East African Court of Justice, the Honorable Justice Kayobera, and the President of the African Court on Human and People's Rights, the Honorable Lady Justice Abud. Our three courts are all situated here in Arusha, the hub of international justice in East Africa, and they enjoy steadfast backing from our standing host state, the United Republic of Tanzania. While our respective mandates may differ, our shared commitment to justice, human rights, and adherence to legal standards unites us. Globally acknowledged, we serve as bastions of legal norms and accountability in Africa, each holding jurisdiction over issues vital to our joint pursuit of justice. Yet, as we discharge our duties, we encounter similar challenges. The intricacies of member state cooperation, sovereignty concerns, diverse legal standards, and national interests pose formidable hurdles. Likewise, those who tackle the prosecution of atrocity crimes or other human rights violations at the national level, including many of the eminent judges and legal experts here with us today, also face a multitude of obstacles. This is why we are gathering today and tomorrow, to engage with one another, share experiences, and gain valuable insights that will expand our knowledge and enable us to better surmount the difficulties we face. I am greatly entrusted by the distinguished panelists and moderators who have graciously agreed to participate in this event, and who will bring extensive expertise from many different legal traditions. Through our exchanges, the second judicial colloquium endeavors to enhance capacity building while fostering collaboration among various national, regional, and international entities, particularly those with overlapping mandates. I believe that this exercise is particularly timely, as this year marks the 30th commemoration of the genocide against the Tutsis in Rwanda, as well as the 30 years since establishment of the ICTR, which spearheaded the presence of international courts operating in the region. Both ad hoc tribunals and the mechanism have been instrumental in developing jurisprudence, procedure, and best practices for prosecuting the most heinous international crimes. Although the mechanism no longer handles active core crime cases, there are still over 1,000 indictments pending for individuals accused of genocide crimes in Rwanda alone. In my discussions with Rwandan authorities, they have emphasized the importance of our collaboration in combating impunity. And while we stand ready to provide specific assistance to Rwanda and other jurisdiction states, I believe our expertise can contribute on a broader scale. In this regard, it is also worth noting that in the past year alone, more than 100 judges, chief justices, and other senior judicial officers from various African countries have visited the mechanism, eager to learn about the operations and technological advancements, and signaling a growing interest in bolstering regional cooperation in combating impunity. Our discussions over the next few days will center on three critical areas that hold paramount significance for all of us. Firstly, ensuring the protection of human rights throughout criminal proceedings for atrocity crimes. This encompasses issues such as assessing the fitness of elderly accused persons to stand trial, ensuring adequate legal representation, and striving for the harmonization of justice standards. Secondly, addressing the current challenges and drawing lessons from experiences related to transnational and international cooperation. This involves enhancing judicial dialogue and effectively adjudicating atrocity cases. Lastly, exploring the utilization of new technologies, including those facilitating remote participation across national, regional, and international court systems. I am very much looking forward to stimulating and thought-provoking interactions in the coming days and hope that the event also provides ample space and opportunity to foster personal networking. My intention is that together we shall forge pathways towards strengthening cooperation and the rule of law in East Africa and beyond. Thank you very much. With this, I'm pleased to give the floor to the Honorable Justice Nestor Cayo Vera, the President of the East African Court of Justice.
Yeah, thank you so much, my sister. You know, we have been collaborating closely with Justice Graciela, but also with my sister and my neighbor, the President of African Court. So our chief guest, the Honorable Minister of Constitutional and Legal Affairs from the United Republic of Tanzania, the justices and the judges and all other judicial officers, the legal practitioners, the prosecutor generals. I can see my brother Aimable, Prosecutor General from the Republic of Rwanda. This is a very important colloquium, and participants may think, why the East African Court of Justice, which is not a criminal court? And even the treaty does not have express human rights jurisdiction, because under the treaty, our court does not have express human rights jurisdiction. But notwithstanding its mandate under Article 23(1) of the treaty is to ensure that there is adherence to the law in interpretation, in application, and in compliance with the law. It means the law of the community, which means the treaty, the protocols, and also annexes, you know, even the decisions from the Council of Ministers, the Acts of Parliament, but also from the decision of our court. So our court has been coming in the areas of criminal atrocities, even if it is not a criminal court or a human rights court. Because under Article 6D of the treaty, it refers to the fundamental principles that shall govern the achievements of objectives of the community by the partner states, which means the principle of good governance, the rule of law, access to justice, social justice, but also the principle of human and the people's rights in accordance with the Charter on Human and the People's Rights. It means that our court also is mandated to interpret the African Charter on Human and the People's Rights in accordance with Article 6D of the treaty, but also Article 7(2) of the treaty, which is about the operational principle of the treaty. It requires the partner states to behave in accordance with accepted principles of human rights. You will see that among the almost 800 cases which have been filed in our court, almost 90 cases has been filed under Article 6D and 7(2) of the treaty, referring to the fundamental and the operational principles. If you read, for example, the case of James Katabazi and 21 others against the Republic of Uganda and the Secretary General of the East African Community, James Katabazi and the 21 others, they've been prosecuted for treason and other criminal offenses by the Republic of Uganda. But when they were given bail, the whole process were interfered by the military officials of the Republic of Uganda. So instead of being given the bail, they were arrested by the military officials. So that case, because the James Katabazi and the 21 others, now they appear to the Constitutional Court, but also the military officials, they also interfered with the process, the proceedings. James Katabazi and others, they filed their case to East African Court of Justice for violation of the principles under Article 6D and 7(2) of the treaty by the Republic. And the court decided that the Republic of Uganda has violated the principles and its obligations under the treaty. If you read the case of Placida Rugumba against the Republic of Rwanda, Placida Rugumba was being prosecuted by the public for a number of criminal cases. But Placida, the subject of Placida Rugumba, when it was prosecuted, her sister, who was living in Uganda, he filed a case against the Republic for violation of the treaty, because the subject has been detained about 5 months without taking to court of law. So when the matter was brought to court, our court said the Republic has violated its principles under the treaty. So you can see that our court does not have criminal jurisdiction, but whenever the partner states are prosecuting the criminals, they must behave and also respect their obligations under Article 60D and 7.2 of the treaty, relating to social justice, rule of law, and also the accepted principles of the treaty of human rights. If you read the case of, for example, which involves Male Mabirizi against the Republic of Uganda, he was in jail in Uganda, but he was able to appear before the court from the jail using the ICT, the technology. So you can see that our court does not have direct human rights jurisdiction, but the partner states in prosecuting the criminals, they must also believe and behave and also respect the fundamental principles of human rights which are under the treaty. So this kind of colloquium is very important for us, that at least the partner says the way they behave in the community. Every day we are meeting in the Forum of Chief Justice. I can see the Chief Justice from Zanzibar. I can see the Chief Justice from South Sudan. And other, because we have the Forum of Chief Justices, we are always telling our judicial officials that even in the criminal offenses, the criminals must be respected, because they also enjoy their human rights jurisdiction under the treaty. In briefly, that is that's our court, which is the judicial court under Article 9 of the treaty, with the mandate to ensure compliance with the law of the community. Asante sana.
Thank you very much. And to conclude today's opening panel, in addition to Her Excellency Dr. Pindi Chana, we will hear from another influential Tanzanian, the Honorable Lady Justice Imani Daud Abud, President of the African Court on Human and People's Rights. Justice Abud, you have the floor.
Thank you very much. Good morning, all. Allow me to stand on existing protocol. I'm honored to address you today at this second judicial colloquium on the new pace of atrocity crime proceedings, internationalization of standards, regional dialogue on procedural and cooperation matters, and use of new technology. This colloquium presents a timely and crucial platform for discussing the evolving landscape of prosecuting atrocity crimes. As the international community strives for accountability and justice for the most serious international crimes, we must continuously adopt and refine our approaches. As we gather here, it is particularly imperative to acknowledge the significance of the interactions among judicial bodies that will undoubtedly shape the course of our discussions. In this regard, I should note that the device composition of panels, including eminent jurists from various regional and international courts, creates a unique opportunity for a collaborative and enlightening dialogue. The benefit of interactions among peers extend beyond the exchange of legal knowledge. They foster a spirit of collegiality and mutual understanding among regional, national, and international judiciaries, such as interaction provide a platform for sharing best practices, lessons learned, and innovative approaches to addressing the complexity challenges posed by atrocity crimes. Furthermore, the convergence of legal minds from different jurisdictions enriches our collective understanding of the evolving landscape of international justice. It allows us to appreciate the nuisance and complexities inherent in our respective legal systems, promoting a more holistic approach to the pursuit of justice for victims of atrocity crimes. Most importantly, interjudicial interactions help us to harmonize and internationalize standards, which in turn is crucial in ensuring fairness, consistency, and effectiveness in atrocity crimes proceedings. The adoption of instruments like the Rome Statute of the International Criminal Court, ICC, has established a framework for addressing these crimes at the international level. However, challenges remain in ensuring universality and consistent application of these standards across different jurisdictions due to particularly lack of similar standards. To overcome these various initiatives have been taken at national, regional, and international level. In Africa, initiatives like the African Union Judicial Dialogue serves as a platform to promoting the harmonization of national legal systems with international standards. The dialogue is a biennial event that brings together chief justices, constitutional court presidents, and judges from across the continent to foster regional cooperation and exchange best practices in prosecuting atrocity crimes. Upon the decision of the Executive Council of the African Union, the African Court has been the implementing focal institution of the dialogue. And so far, the African Court has organized 6 dialogues, of which the last one was held in Algiers in November last year. The African Judicial Dialogue has proven successful in offering national judiciaries a regular platform to discuss contemporary issues and share experiences, leading to initiatives like the establishment of an African Judicial Network and online African human rights calls. While the dialogue has not yet explicitly addressed atrocity crimes, the theme, challenges, and opportunities discussed so far have positively impacted the capacity of national judiciaries to try and punish such crimes. Regional dialogues are therefore essential for fostering cooperation and exchange of best practices among national courts and tribunals. These dialogues can address specific challenges faced by different regions, promote mutual understanding of legal systems, and contribute to the development of regional jurisprudence on atrocity crimes. Excellencies and distinguished guests, when we discuss the evolving landscape of atrocity crimes proceedings, it would be remiss to not talk about the critical and complex realm of new technologies. These advancements undoubtedly reshape the way we approach investigations, evidence collection, and ultimately the pursuit of justice. The emergence of new technologies presents both opportunities and challenges for atrocity crimes proceedings. Speaking of opportunity emerging, for instance, satellite imagery capturing undeniable proof of atrocities, or drones footage exposing hidden mass graves. Social media, once a platform for connection, can now offer crucial evidence trials for investigators. Advanced data analytics have also become powerful allies, processing mountains of information, uncovering patterns, and connecting seemingly disparate dots. This translates to stronger case and more efficient investigation. Furthermore, transparency and accountability are bolstered by secure online platforms that facilitate sharing of evidence and information with victims, survivors, and the public. Justice, once shrouded in secrets, is brought closer to the light. With the advancement of technology, witness protection has also taken on a new form, allowing individuals to testify remotely, shielding them from the dangers of retaliation. However, these advancements come with their own set of challenges. The first challenge pertains to ethical considerations. Data privacy, the potential for surveillance, abuse, and inherent biases in algorithms demands careful navigations. We must establish robust safeguards and ethical guidelines to ensure responsible use of this new technology. The digital divide also presents a stark reality. Access to and expertise in these technologies vary drastically across regions, potentially creating disparities in investigations and prosecutions. Bridging this gap is crucial. Cybersecurity threats further pose a constant danger. Digital evidence, once compromises, can be manipulated or even disappear entirely. Robust security measures are essential to safeguard the integrity of justice. Finally, capacity building becomes paramount. Judiciaries and investigators requires training and support to effectively utilize these technologies and interpret the data they generate. In conclusion, collaborative efforts among judicial bodies also strengthening the foundations of international law and contribute to the harmonization of legal standards. This in turn enhances the effectiveness and credibility of our collective pursuit of justice. By fostering relationships and cooperation among judiciaries, we create a robust framework of addressing the evolving nature of transnational and international crimes. Distinguished colleagues and participants, I'm confident that this colloquium presents a valuable opportunity to engage in critical discussions and chart a course forward for strengthening atrocity crime proceedings. I wish you a productive and fruitful experiences during our discussions over the next 2 days. May these conversations be marked by insightful exchanges and collaborative solutions, driving us forward in our pursuit of justice for atrocity crimes. Thank you very much for listening. Asante sana. Muito obrigado. Merci beaucoup.
Asante sana, Judge Gabriela Gatti Santana, Honorable Justice Nesta Kayobera, and Honorable Lady Justice Imani Daud Abudi. I will now welcome the keynote address. Yes. A round of applause, please. Thank you. We'll now welcome a keynote address from Ms. Alice Wairimu Nderito, United Nations Under-Secretary General and the Special Advisor on the Prevention of Genocide. Welcome.
So, Honorable Minister of Constitutional and Legal Affairs,
the United Republic of Tanzania, and the President of the International Residual Mechanism for Criminal Tribunals, and the President of the East African Court of Justice, the President of the African Court on Human and People's Rights, and many friends that I see in the room, eminent judges, excellencies. I'm honored to join you today for the second Judicial Colloquium of the International Residual Mechanism for Criminal Tribunals on a topic very close to my mandate, namely the new phase of atrocity crime proceedings, internationalization of standards, regional dialogues on procedural and cooperation matters, and use of new technologies. So let me start with the obvious of why this matters. By enhancing our ability to conduct atrocity crime proceedings, to which indeed internationalization of standards, regional cooperation, and use of new technologies contribute, we advance justice. With this, we honor the victims, determine the facts of what has happened, and by doing so and by bringing perpetrators to justice, we build solid foundations for prevention. So as a special advisor to the United Nations Secretary General on the prevention of genocide, my mandate is to monitor and raise alarm over situations across the world where there is a risk of genocide or related crimes, by which I mean war crimes and crimes against humanity, also referred to as atrocity crimes. I'm also mandated to raise awareness on the causes and dynamics of these crimes and to strengthen the capacity of member states, regional organizations, and civil society to prevent them. My mandate is on prevention, not on adjudication. I often must emphasize to many who ask that I pronounce whether a genocide has occurred or is occurring, that I do not have the mandate to make a determination if a particular situation amounts to genocide or other related crimes. This, of course, is a mandate of judicial institutions with the relevant jurisdiction, including, of course, the residual mechanism. However, the connection between accountability for genocide and related crimes and their prevention is indisputable. We know that genocide was codified in international law through the adoption of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. The convention created the dual obligation on state parties to both prevent and punish this crime. Last year, we marked 75 years since the adoption of this landmark convention. And I'm grateful that many of you here in this room were present in this commemoration at the United Nations headquarters in New York in December, when we honored the tireless work of Raphael Lemkin, who gave the crime a name, genocide, and who lived a life consistently challenged by the fact of the existence of a name for the crime of killing one person, murder, and none for the killing based on identity of a group of people. So Lemkin also led efforts in codifying the crime and making the adoption of this convention a reality. So at the 75th commemoration, we also emphasize the legacy of this pillar of international law and the many ways in which it has contributed to the international criminal law framework that we have in place today, as well as to the prevention and punishment of genocide at the international, regional, and national levels. So indeed, the statutes for international and hybrid tribunals set up to prosecute the most serious crimes in Rwanda, in the former Yugoslavia, in Cambodia, and in other places have been based, as it could not be otherwise, on the definition of the crime of genocide as set out in the Genocide Convention. The work of these tribunals has in turn helped us have a stronger understanding of the scope of this crime, its devastating impact on victims, as well as the rights that victims have, including to reparations. In addition, pioneering as it was already in 1948, the Genocide Convention in Article 6 envisaged the possibility of an international penal tribunal that may have jurisdiction for the crime of genocide in the future. This took many decades as the path towards justice is sound but slow. But in 2002, as we know, the International Criminal Court became operational with jurisdiction over the crime of genocide, based on the definition as set out in the convention. The 1948 convention has also enabled the adoption and implementation of domestic legislation across the world, making genocide punishable in domestic jurisdictions. So while acknowledging these achievements, we know that the convention has not been entirely fulfilled in terms of the noble aspirations that were envisaged at its adoption.
While 153 states have ratified this text, 41 are yet to do so. And far too often, states fail to implement the obligation of the convention and to fulfill the commitment of never again, with horrific consequences for victims. The tribunals for Rwanda and the former Yugoslavia were both established by the Security Council because of the failure to prevent the crimes in the first place. So today, we know the warning signs of genocide and related crimes. We know the risk factors. It is not the lack of information about violations of rights that may lead to a genocide that is hampering prevention efforts. It is the lack of action. In our office, we have developed a framework of analysis for atrocity crimes, which sets out these risk factors. This is the methodology we use to assess situations across the world and on which we base our early warning. This framework was developed based on extensive consultations and through research of the elements that were present in past instances of commission of such crimes. The verdicts by international tribunals, including analysis of the crime of genocide, were among the resources used to identify these risk factors. This demonstrates just one of the many ways in which accountability for these crimes can help inform and enhance prevention efforts. But there are many more. Let me address two, which are part of the themes for the discussion of this colloquium. So, namely, the importance of cooperation for accountability purposes, facilitated by internationalization of standards and the use of new technologies. Increasing cooperation for accountability is crucial to ensure the safeguarding of the significant steps towards justice and accountability for past crimes that have been achieved by the ICTR, ICTY, and the residual mechanisms, and also that brought perpetrators to account. We follow closely the progress of the mechanism, and I always issue statements in support of the arrests. We do know that many indicted people are still at large, living in countries that are member states of the United Nations. Undoubtedly, this impunity undermines what my office stands for. It is therefore incumbent on my office to join hands with the residual mechanism and all parties seeking accountability for perpetrators of atrocity crimes, as well as to help provide a strong deterrence to would-be perpetrators of atrocity crimes. The success of judicial institutions in ensuring accountability is often dependent on such cooperation. This includes with domestic judicial systems, which must play a leading role. So, and as my friend, the prosecutor of the IRMCT, Saj Bramat, has stated repeatedly, national prosecutions are not optional. They are essential. The success of regional cooperation is less a matter of technical coordination and more a matter of political will. It is important that all UN member states extend cooperation to the Office of the Prosecutor of the IRMCT to apprehend and bring to justice genocide perpetrators and fugitives living in their territories, and I acknowledge the good efforts of the member states who have done so. Without cooperation, justice cannot be fully served to victims. It is critical for them and society more broadly to heal. This is because justice is not only about the past, it is also very centrally about the future. Without such cooperation, plain and simple, many perpetrators will not see their day in court. We also know that justice for the gravest crimes cannot depend only on the work of international tribunals. While high-level cases have been successfully prosecuted at this level, and all of you here are living testimony of this, many serious allegations are left unaddressed simply because there is no sufficient capacity to prosecute all cases. Cooperation based on international standards therefore becomes paramount to expand the wings of justice and to bring it to all affected victims and communities so that they can heal and move forward. This too is essential for prevention. So, ladies and gentlemen, let me now turn to the use of new technologies. The rapidly changing technological landscape that we are seeing all around us presents many opportunities to enhance our work on prevention and accountability for international crimes. New technologies allow for collection of evidence in ways that years ago was inconceivable. I saw this practically in Iraq. So the importance of the good work of the United Nations investigative team to promote accountability for crimes committed by Daesh, and that's the UNITAD mission in Iraq, for example. These new technologies allow efficient ways to preserve, store, and manage evidence, to facilitate connection with witnesses, and to allow parties to participate in proceedings remotely. But they are, of course, not without challenges. New technologies can support judicial proceedings enormously, but they are also part of the problem in enhancing the risk of international crimes in the first place. This takes me to hate speech. My office is the United Nations system-wide focal point on hate speech globally, and we see firsthand through our work on tackling hate speech the severe negative impact of social media and the algorithms that they are based on in accelerating hate and incitement at unprecedented speeds. Hate speech, in particular, when it reaches the threshold of incitement, is one of the indicators of risk of genocide and related crimes that my office looks at. We do know from history that hate speech and dehumanization of the other has preceded the commission of genocide. The role of hate speech and incitement on the commission of genocide has also been highlighted through the judgments of the International Criminal Tribunal for Rwanda in what we call the media case. Today, we see such tactics being put in place through the use of social media. This is allowing hate to disseminate much faster and to a much wider audience. And hatred expressed with words does not stay at the level of discourse. It constitutes a call to act and to kill. We have seen this in the lead up to the violence against the Rohingya in Myanmar in 2017, against the Yazidi in Iraq in 2014, or even against the Masalit in West Darfur, Sudan today, a situation for which I have issued the most statements that I've ever issued ever since I joined this office. At the United Nations, in view of these challenges, the Secretary General launched a system-wide strategy and plan of action on countering and addressing hate speech in 2019. My office, as the designated global system-wide United Nations focal point on hate speech, as mentioned, leads implementation of this strategy, and we support efforts by member states, United Nations field offices, and civil society to do precisely this, including with the development of action plans aimed at this purpose. We also engage directly with tech and social media companies. Last year, we published a policy guidance, Countering and Addressing Online Hate Speech, a guide for policymakers and practitioners on tackling online hate speech. It sets out key recommendations arising from consultations with a range of relevant interlocutors from tech and social media companies. This followed my October 2021 brief to the Security Council on the topic of social media and hate speech in conflict context, to which we invited Google, YouTube, Twitter, and Facebook as core briefers. We have since expanded our engagement to smaller tech companies such as Slack, Twitch, Zoom, Reddit, many more. We are now engaging with tech and social media companies with limited content moderation policies that are, however, highly utilized in several contexts to spread hate and incite violence that could lead to atrocity crimes. Also in 2023, the Secretary General published a dedicated report to the Human Rights Council on the prevention of genocide and on the impact of new technologies on its prevention, the prevention of this crime of genocide. And this report called on states and tech and social media companies to apply a genocide prevention lens in their efforts to address online harms, including hate speech, to ensure that legislation and regulations also prohibit public and direct incitement to genocide in line with the Genocide Convention, and for companies to signal patterns of hate and to take action so that online platforms are not utilized for incitement or planning of genocide and related crimes. Companies are also asked to preserve potential evidence of crimes, including materials removed. In addressing new technologies, we cannot ignore the reach and influence of artificial intelligence. We are yet to fully understand how AI can be effectively used to support actions to prevent international crimes. On the opposite direction, we also need to fully understand how AI can be instrumentalized to incite hate speech and the commission of such crimes. But we have many reasons to be seriously concerned. To better understand the integration of AI into our lives and to foster a globally inclusive approach to this new technology, the Secretary General recently convened an AI advisory board. In assessing the risks of AI, the board pointed out that some risks of AI are more a product of humans than AI itself, and brought examples of deepfakes and hostile information campaigns that resort to technologies for malevolent ends. So I'm sharing all of this with you today because I think the exponential spread of hatred through the use of new technologies will be at the core of future criminal proceedings in addressing allegations of international crimes. The words that preceded genocide in the past can now be propagated exponentially and with the support of artificial intelligence to an unlimited audience and through unlimited means. This is a rapidly evolving issue that we need to take into account when considering the new phase of criminal proceedings for international crimes. So unfortunately, we see similar trends when it comes to a very important topic, and that's the topic of genocide denial. Denial or distorting the facts of the genocide against the Tutsi in Rwanda, and in Srebrenica, the genocide against the Bosniak Muslims in Srebrenica in Bosnia-Herzegovina, come in the form of hate speech and do constitute an indicator of risk for the commission of genocide. Despite the International Criminal Tribunal in the former Yugoslavia and the International Criminal Tribunal for Rwanda having proved repeatedly, conclusively in lengthy legal processes and applying international fair trial standards and the standard of proof beyond reasonable doubt that the genocide against the Tutsi in Rwanda and against Bosniak Muslims in Srebrenica happened, revisionists and genocide deniers continue to ignore judicial decisions. These trends are especially worrisome as we are marking this year the 30th commemoration of the genocide against the Tutsi in Rwanda, and next year, the 30th anniversary of the Srebrenica genocide against the Bosniak Muslims. This time should be spent honoring and commemorating victims, remembering and learning from the past. Instead, we are faced with the challenge of addressing growing trends of denial and distortion of these tragedies. Social media, similar to hate speech, is helping to spread and amplify denial at alarming rates. Genocide denial impacts directly on victims who are re-traumatized and faced with the burden of having to justify and explain the crimes they endured, despite the courts having conclusively determined that the crimes occurred. Denial has a serious detrimental impact on healing and reconciliation. I have seen this firsthand in Bosnia and Herzegovina. In my meetings, for example, with Ms. Munira Subasic, who many of you may know, she's the president of the Association of Mothers of Srebrenica, and I greatly respect and admire her. And she's confided to me the strong disappointment by so many that genocide denial continues happening almost on a daily basis and with no consequences in Rwanda and in Bosnia-Herzegovina. And I've had this in Rwanda too, over and over again. Victims understand very well that genocide denial refers to the past, but that its impact is felt in the present and will be felt in the future. They do not want the young generations to experience what they have already experienced. And with the aim of addressing this problem, in 2022, my office published a policy paper titled Combating Holocaust and Genocide Denial, Protecting Survivors, Preserving Memory, and Promoting Prevention. This policy paper, based on expert consultations, sets out recommendations for member states, the United Nations, tech and social media companies, as well as civil society. It also makes a very important point that Holocaust denial and genocide denial is connected, that genocide deniers borrow the template from Holocaust deniers. They do not use any new arguments that have not been used by Holocaust deniers. They use the very same arguments, the very same methods. So I do believe that the work of the tribunals and the residue mechanism is crucial in these efforts. We will never manage to fully eradicate denial, unfortunately, but we must do our best to limit its damaging impact. The judgments, archives, and records of the courts provide a starting point for educating societies about genocides and the past to learn from and address the root causes that led to their commission in the first place. They also provide the undisputable evidence that these crimes occurred. This is and will continue to be an important legacy of the tribunals. We need to continue our partnership with the residual mechanism and build such awareness. This is an area where we can use the positive potential of new technologies to reach new audiences and to package messaging on what are inherently complex and difficult topics into something that society at large, including the younger generations, can connect to and engage with. We can also partner to provide such education on genocide and related crimes in a formal setting. Here in Arusha, through dedicated educational programs on the different aspects of the work of the tribunals and on their connection to the prevention of genocide. Many academic and research institutions, universities, and institutions of higher learning do not have specific academic programs on genocide studies. Most of the studies relating to genocide or other atrocity crimes are established as sub-programs or optional courses within overarching disciplines in these institutions. So a Center for Genocide Awareness and Prevention here in Arusha can be part of the legacy of the ICTY, ICTR, and the residual mechanism that we together can work to preserve, building on the impressive infrastructure and work that the Registrar, Abubakar Tambadu, oversees here. Such programs could be taught in a dedicated space through regular courses and targeting different sets of academic and professional audiences. This is an idea that I would be ready to discuss with all of you, as the work done by the ICTY, the ICTR, and the residual mechanism creates for us, and especially my office on the prevention of genocide, an imperative to ensure a continuous academic engagement of a factual understanding of the past on how genocides happen and therefore how they can be prevented. We can only do this through the work that has been done by you. In Bosnia-Herzegovina, they tell me consistently that it is time for the knowledge that was generated by yourselves as judicial officers, as judges, as prosecutors, to move from the courtroom to the classroom, from the courtroom to the classroom. So this is what I envisage here in Arusha. And in addition, we do know that a lot more needs to be taught. Normative and institutional frameworks for the prevention of genocide continue to be developed. So I'll give you an example from this continent that I come from. The Constitutive Act of the African Union requires the regional organization not only to prevent violent conflicts, but also to intervene in its member states to prevent genocide, war crimes, and crimes against humanity, that's atrocity crimes. The African Union elaborated an African Peace and Security Architecture, what we call APSA, and developed an early warning mechanism for conflict prevention, known as the Continental Early Warning System, including an African standby force to intervene in situations that are at risk of atrocity crimes. And we know that in 2006, member states of the International Conference of the Great Lakes Region, the ICGLR, adopted a protocol for the prevention and punishment of the crime of genocide, war crimes, crimes against humanity, and all forms of discrimination. And under this protocol, member states are required to domesticate and enforce its provisions by putting in place laws that will prevent and punish genocide, war crimes, and crimes against humanity. Measures that will eliminate discrimination, teach and encourage tolerance among national, racial, and ethnic groups, combat impunity, and extradite criminals. My office assisted the ICGLR to establish the Regional Committee for the Prevention and Punishment of the Crime of Genocide, War Crimes, and Crimes Against Humanity, and all forms of discrimination. In addition, the ICGLR protocol mandates each member state to establish a national committee for the prevention and punishment of the crime of genocide, war crimes, and crimes against humanity, and all forms of discrimination. And so far, with the support of my office, all the countries in the region, including Tanzania, have national committees. At sub-regional level, regional economic communities have elaborated and advanced early warning mechanisms based on the conflict and early warning system model. But all these examples that I've given, we do know that there are limitations in terms of their ability to trigger an effective response to preventing genocide and related crimes. And part of that limiting of that ability is caused by the fact of not having moved the knowledge from the courtroom to the classroom. The consistency with which we get requests for capacities to be enhanced is one of, I would say, close to overwhelming. All the time we get all these requests. Can we know what happened at the ICTY? Can we know what happened at the ICTR? How can we apply the lessons from the ICTY, the ICTR, the residual mechanism to what we are practically doing? This is so consistent. So the Republic of Zambia became the latest United Nations member state to become party to the Genocide Convention in July 2022. So Zambia has also become the latest member state of the ICGLR to set up a national committee for the prevention and punishment of the crime of genocide, war crimes and crimes against humanity, and all forms of discrimination with our support. And so I've been invited for the launch next month on March 22nd for this committee. But they've also, again, as expected, requested capacity enhancement of the new committee on the role of the ICTY, the ICTR, the residual mechanism. This and other numerous requests that my office gets daily, as I've mentioned, drive home the need for the additional dimension to the prevention of genocide that can be introduced by the role and function of a Center for Genocide Awareness and Prevention here in Arusha. From the courtroom to the classroom, I cannot think of anything more important, moving this knowledge from the courtroom to the classroom. So, ladies and gentlemen, I want to conclude. And in concluding, I want to highlight the importance in all of this of your role, of how important it is that we have here in this room and in many places in the world, judicial officers who've served in the ICTY, the ICTR, the residual mechanism, who have the knowledge to become resource persons in this Center for Genocide Awareness and Prevention. That it's almost perfect that here you have the work that's been put together. It's all in one place, and you have resource people, and all we need to do is to take action in terms of working to set up this Center for Genocide Awareness and Prevention here in Arusha. And we've reached out also to the government of Tanzania requesting that this happens. So we do need, above everything, to put front and center the voices, views, and concerns of victims and survivors of the genocide against the Tutsi in Rwanda, of the genocide in Srebrenica against the Bosniak Muslims. And the rights of victims and survivors have evolved tremendously over the last few decades and through the work of international tribunals that many of you have presided over. But we do know more needs to be done. We know the pivotal role played by victims. In both the cases of Rwanda and Bosnia and Herzegovina, it was the victims who stood up to advocate for justice, for their stories to be heard, and for perpetrators to be brought to justice. Had it not been for their testimonies, their courage, reliving their trauma, accountability may not have been possible. So in Rwanda and in Bosnia and Herzegovina, I especially laud the work that was done by women. In Rwanda, the bravery of women highlighting the pervasive use of rape and sexual violence as part of the genocide against the Tutsi, and testifying before the courts to these horrific crimes, despite the stigma that remains attached to them. We are sure, would not have had the famous landmark ruling that was mentioned by the minister, the Akayesu case, that ruled that rape and other forms of sexual violence could constitute genocide. We do know the role that has been played by the mothers of Srebrenica, how in addition to being survivors of the genocide, losing their brothers, sons, fathers, that they went to court, they testified, and they continue to look for missing people up to now. They continue to find dead bodies. They continue to advocate. They continue to be very, very strong. So victims and survivors have committed to fight for truth and justice. And I consider to leave to you the words of Munira Subasic, who is the president of the Mothers of Srebrenica. Very, very strong woman. And she says, she puts it this way. She says, our commitment will endure as long as we live, as long as we're in good health, as long as we can speak up, and remember, and as long as we can breathe. We in this room have done quite a lot. We in this room cannot do any less for these victims. Their perseverance is our driving force. Their voices remain our guidance, and their needs our call to action. So let us continue working together to serve them as they deserve. So I say thank you very much. I look forward to these 2 days. I've looked forward for quite a bit of time ever since I got the invitation. I'm very grateful, Madam President, and very grateful also to be in Tanzania, in the region where I come from. Asanteni sana, nashukuru sana, because here we are mapping a way forward. Thank you very much.